101, what types of behaviors would you typically be telling callers to look for?
Well, I think for most people, and of course there's always exceptions to the rule, but I think in most abusive relationships, survivors tell us that the controlling features of the relationship start very early. And a lot of times those might be behaviors that they wouldn't necessarily right away identify as controlling. The fact of the matter is that our culture tends to romanticize some of those controlling behaviors. For example, someone calling all the time, or
Right.
Constantly wanting to be with you, or sort of
Right.
saying, don't go out with your friends, stay here with me tonight. Those things that seem very benign in the
Right.
beginning can very quickly escalate to behaviors of isolating the victim from friends and family, being very controlling, expecting that person to report into them, expecting to know where the victim is all the time. And those can then gradually over time escalate into more physical behaviors,
Right.
sometimes starting with a slap or a push, and escalating into punching, use of weapons. It
Right.
really, the general rule of thumb is that over the course of time, domestic violence increases in both frequency and intensity. So what may start out as 1 or 2 incidents over the course of, say, a month, 5 years down the road, those incidents are happening weekly,
Right.
and they are more severe.
Right.
So.
So then, assuming that a viewer or a caller, rather, would contact your office and you were to spend some time with the caller and then ascertain that it would be appropriate, let's say, for this caller to come to court and get or file a petition for an order of protection, you have people to help with that process.
Absolutely.
Is that right?
We have 4 full-time advocates at court that assist with orders of protection, assist with those petitions, and actually accompany people all the way through that process, from the writing of the petition to accompanying them to court, standing in front of the judge with them, helping to give them emotional support, explaining the process of court to them so that they know what to expect, they aren't surprised by anything,
Right.
helping them get the paperwork to the sheriff to get it served. And we do follow up with people as well after
Right.
they get their orders to find out how is the order working for them. Have they had any violations of the order? What's the response been from law enforcement? Are there any barriers that they're facing in terms of getting back to court and extending that order? And are there any ways that we can help them address those obstacles?
I see. So in the proper set of circumstances then, if an emergency order of protection was filed, you might very well find yourself in Judge Beth Sexton's courtroom. Is that right?
Could be.
And Judge Sexton, let me ask you, in that situation that we've just talked about, where a caller ends up with one of Amy's volunteers in your courtroom, and let's say that you do a hearing on this matter and you find that there has in fact been grounds or such a problem that rises to the level that you would issue an order of protection. Can you tell our viewers what some of the remedies are? I mean, what's available to help these people?
Okay. I think initially what we're talking about, Amy, here is an emergency order of protection.
Right, correct.
Where they come in without notice to the perpetrator because of fear that this will continue and things will escalate if they know about it. There are several things we can do. We can do a stay away order and get people to stay away from you.
So that's exactly what the name implies.
It's called a
an
stay away
to stay
order.
away. Wow.
Under certain circumstances, we can give exclusive possession of a residence under some circumstances. We can protect the children. We can prohibit people from concealing children in the state or prevent them from taking them out of the state. There are many remedies that we cannot give on an emergency order. Those are pretty short hearings. They aren't really hearings. You look at the petition and you decide whether you want to ask a few questions, but it's under oath. So they're pretty summary hearings. They're not a lot of testimony taken. And then we go to hearing on a plenary order if the emergency is issued. and that's usually about 21 days later, and notice is given to the other party, and they can come in and contest it if they want. Now on that, we can give child support, custody, or visitation rights. Not much of that is available on an emergency order.
Right.
Temporary possession of children, but if you want anything more in depth, that you have to come back and